Welcome to the New Books Network.
Welcome to Madison's Notes, the official podcast of the James Madison Program of American Ideals and Institutions at Princeton University. This week, our guest is Janie Nitze, who most recently served as a Senate-confirmed board member of the Privacy and Civil Liberties Oversight Board. She was a fellow at Harvard Law School, where her areas of scholarly interest focused on separation of powers and national security, and was also an attorney with the Office of Legal Counsel in the Department of Justice. Janie received her bachelor's in physics and her master's in statistics from Harvard University and her JD from Harvard Law School. She clerked for Justices Sonia, Sotomayor, and Justice Neil Gorsuch of the U.S. Supreme Court, but today is here to discuss her co-authorship of Overruled: The Human Toll of Too Much Law, written by her and Justice Neil Gorsuch. We discussed how today our laws in the United States have grown so vast and reached so deeply into our lives that it's worth asking, in reverence for law, is there too much of it? We discuss the historical precedents and the building of law. We discuss the relationship between lawmaking and executive power. And we discuss how excess legislation poses challenges for the American public and ways in which this could be addressed. So let's welcome Janie onto the show. Well, Janie, welcome to the show. Really looking forward to this conversation with you, discussing your co-authored book, Overruled: The Toll of Too Much Law, which you wrote with Supreme Court Justice Neil Gorsuch. Welcome to the show.
Thank you so much for having me. I'm really thrilled to be here.
Yeah. Well, so first of all, looking at your background, I'm always curious about how somebody gets to where they are. Co-authoring a book with a Supreme Court justice is maybe not in the bingo card that you had for life when you started out. And I saw that you did an undergraduate in physics. Could you give me a little bit more of a background of how you got to this point and how you got to the work that you're in today?
Sure. No, I'd be happy to. I might take it even a step before physics just because it makes sense sort of later on. I grew up in a household where I was constantly being made aware of sort of the uniqueness of this nation. So my parents are immigrants. They fled communism from their homeland in Czechoslovakia and came here to America. And they very much did not take for granted the liberties that they found here in this country. And they impressed upon me and my brother really at any occasion possible, ski chairlifts, dinner, etc., the sort of miracles of this country and the freedoms that we have here. That said, I didn't grow up in an overtly political household. My parents weren't lawyers, they weren't activists, they weren't donors and so forth. And I was left to pursue really whatever I wanted in school, so long as I pursued something and pursued it hard and worked hard. And in high school and college, that was math and physics. I loved the structure of those subjects. So I got my undergrad in physics, I got a master's in statistics at the same time, and very much thought that I would go into physics as a career. I sort of love the structure of the subjects insofar as there is a right answer to any given problem. And there might be very different ways of getting there and different creative ways of getting there. But at the end of the day, you either get the problem right or you get the problem wrong. And I sort of like the cleanliness of that. And I thought I would be a physicist, honestly, until I spent a summer in an actual astrophysics lab at Harvard. It was run by a lovely professor there, Professor Patrick Thaddeus, who has since sadly passed away. And it was fascinating work. He was sort of, as far as I recall, this is 2 decades ago, but he was sort of bombarding molecules in a lab to create new molecules and looking for the new molecules out in space. And it was fascinating, and also absolutely convinced me that I did not want to go into physics as a career. And, it was clear to me that physics today, I think, unlike maybe a century or two ago, is a very, very narrowly focused topic. You might study the sort of same topic, and in the case of that professor, he studied it for his entire lifetime. You might study it for decades. And it's a deeply creative work that appeals to a lot of people, but it wasn't suited for my personality. And I think at the same time, I was also becoming more conscious of my parents' experiences in their old country and the differences between their old country and our country here. And so much of that comes down to law. And so ultimately, I turned to law school, thinking, I think accurately, but thinking at the time that law would have a heavy analytical component, or somewhat similar to math and physics, but also sweep more broadly in considering sort of how society is structured and how those structures sort of preserve or not freedoms. And so went to law school and loved it, and here I am. But you're right, I did not have on my bingo card.
Well, and you say that your parents, they impressed upon you the values that they saw living in the States as new residents, but they weren't necessarily political. And you've clerked for both Justice Gorsuch and Justice Sotomayor. I'm curious, people would say that those are two opposite ends of the political spectrum. I'm curious how those experiences have shaped your perspective of how political law is, the relationship between those two things, because I think they get conflated quite easily, or it's difficult to tease out the relationship that they have.
Sure, no, I think that's right. Now, I'll just say at the outset, I had just a wonderful time clerking for both justices, and I deeply admire each, and certainly am deeply grateful to each for allowing me to serve in that fashion. You're right. I am often asked how clerking for each was different. And the answer I tend to give is actually not really. Each justice, like the other justices on the court, are trying to get to the right answer on the law. And as the clerk, you're really reading the briefs and writing the bench memos and having conversations within and outside of chambers. And sure, on the margins, things might look a little bit different. In one chambers, you might look at legislative history a little bit more, and the other chambers less so. But in the main, the job is the same. And I do think, to your point, that the differences between those two justices or any justices that are appointed by presidents of different political parties, I think those differences are less pronounced than the mainstream media might paint them to be. Sometimes I read an article nowadays, and it makes it read like there's sort of some conservative, cattle on the court just looking to overturn precedent left and right. I've heard of some justices' calls for the new horsemen of the apocalypse, which was, of course, the nickname given to the conservative justices under FDR back in the day. And the reality refutes that. So I recall reading a couple months ago in the New York Times, there was a great study published, and among other things, it showed that Justices Alito, Gorsuch, and Thomas, the so-called modern henchmen of the apocalypse, they agreed only 59% of the time. And Justice Gorsuch apparently voted, according to the same article, for, quote, liberal results in divided cases, whatever that is, 45% of the time. And then overturning precedents, or that bit, the statistics there are relatively stable over time. And if anything, precedent is overruled a touch less today than it was a few decades ago. But I suppose, sort of back to your question, how it may have influenced my philosophies, I distinctly recall sort of from the early days of clerking for then Judge Gorsuch in Colorado, because I clerked for him on the circuit court and then again for the Supreme Court. He really impressed on his clerks that the point of the Constitution is to protect the individual and to protect their individual liberties, right? And so, yes, we have the separation of powers, and it talks about the executive branch, the legislative branch, the official branch. But at the end of the day, so the splicing and dicing of those big branches of government are all done to protect individual liberty. And that idea that the country was ultimately founded sort of for the individual, for his liberty, for we the people, that has really stayed with me and impacted how I view the current composition of our governments, or the rise of agency power, and some of the other issues that we talk about in the book.
Yeah, before we jump into dissecting the content of the book, I would love to understand a little bit more about what the collaborative process with Justice Gorsuch looked like, and what was the dynamic that produced the content in the book.
Sure. He's a wonderful person to work with and to work for. And I think that was seen when he was elevated to the Supreme Court, where all of his clerks came out en masse, where, whether you're on the left or the right of the political spectrum, so we all came out to support him, because he's really just a wonderful boss, wonderful mentor, wonderful colleague on the book. And, this is a book that we have been talking about doing for years. As I mentioned, I sort of first clerked for him back on the circuit court, really almost 2 decades ago now. And, all the big topics we had discussed over the years, and we knew exactly what we wanted to say on them. And so really just became a matter of how we were going to go into the details of saying it. What stories would we include? Because we really did want this to be a book about stories, and we want it to be accessible to non-lawyers as well. And, when I went back to the book proposal recently, I found that the book we wrote was actually the book we proposed writing, which was a big surprise to me. very much sure not the case for my usual work product. I feel like usually I set out to write an article and by the end, I'm coming to the opposite conclusion of whatever I said, right? So I think that was sort of telling insofar as it really tracked conversations that we've been having for many years.
I really appreciated that about the book is it had a lot of stories and very explicit examples. It wasn't just sort of pie in the sky theory. It was like, here's our ideas, the philosophy or our judgments on what's happening. And here's specific examples of that playing out for American citizens. So I'm curious, there was one of the opening stories is this case of the hip pocket incident from the Supreme Court's early days, like before the Supreme Court even had their own building. Can you recount that story for us and just for our listeners set the tone for the arguments that are going to come up later in the book and how that's reflected in the hip pocket and how that sets us up for the rest of the book?
Sure. So the hip pocket incident was well known at the time, but I think largely forgotten nowadays. And it was an incident that occurred back in the early 1930s in 1934. The Supreme Court gathered to hear a case in which 4 oilmen had been jailed for violating a supposed production quota in an executive order. And the case has sort of progressed through the court system. And at some point it emerged, a problem emerged that no one could actually seem to lay their hands on the executive order that contained this production quota. And during oral argument, the oilman's lawyer stood up and in response to a question from, I think it was Justice Brandeis, in his Southern drawl, he explained that the only true copy of the quota he had ever seen was, quote, in the hip pocket of an agent sent down to Texas from Washington. And, the newspapers at the time reported that even the normally sort of poker-faced Chief Justice, Charles Evans Hughes, cracked a smile. And, the moment was funny, but I think it laid bare for the public and for the justices a real problem, which was that agencies were increasingly writing regulations, but they weren't required to publish them anywhere. Time magazine at the time wrote that some agency regulations were going out as press releases or pamphlets, and nowhere in the land could a businessman anxious to obey the law find in one place all the laws he was supposed to obey. And for some time, sort of federal officials had resisted publishing these regulations for the public, and they argued, curiously, that they weren't in the newspaper business and therefore had no business publishing the regulations. And the hip pocket incident really changed that. In the aftermath of that particular Supreme Court case, the President Roosevelt said he'd look into it. Soon afterwards, the Federal Register was created, and shortly afterwards, the Code of Federal Regulations, which includes, in all the volumes, all the regulations that are on the books. And we wanted to open the book with that story for a few reasons, but primarily because it shows that the issues that we are talking about today, right, the flurry of regulations, the impossibility of individuals to understand what the law demands of them, they're the same issues that matter to people 100 years ago. And yes, there were sort of differences, right? Back then, it was because there was no compilation, right, at all. There was no Federal Register. There was no Code of Federal Regulations. Today, these two large, do exist, but they're so large, so massive that the same problem arises, namely, no one knows what the law demands of them. So just some figures here. When the Federal Register started 2 years after that case in 1936, it was 16 pages long. In recent years, the publication has grown by an average of 70,000 pages annually. The Code of Federal Regulations in 2021, it spanned 200 volumes and over 188,000 pages. And again, that just didn't even exist before 1938. And so again, we wanted to say, the same issues are cropping up over and over again in the last 100 years. And also, these are issues that are not, right-wing issues. They're not left-wing issues. At the time, Justice Brandeis was the one who was really pushing for transparency in publishing regulations. And he was a justice who some people say that his questions at this oral argument really sealed the deal for a Federal Register.
So moving more into the core message of the book, Overruled, can we unpack that a little bit more so it's a little bit clearer? Because I think it's easy for us to hear this example and think, overruled, it must just be about saying there's too many laws. But can you give me a little bit more color to that and how that's broken down and given a little bit more nuance?
Sure. I think you could boil down the core message of the book to this. We live in a republic premised on self-rule and personal liberty. Those core ideals we argue, are being threatened by changes that have been taking place in our legal edifice that have resulted in too many rules emanating from the wrong places by the wrong people and resulting in less freedom. I think so. That's how I boil it down. And so to unpack that a little bit, so too many rules, what do we mean by that? So again, listeners can bear with me on some statistics and numbers for a second. Less than 100 years ago, all of the federal government statutes fit into a single volume. Today, the U.S. Code encompasses 54 volumes and 60,000 pages. And that's only statutory law. Nowadays, we obviously have agencies writing rules that carry the force of law. We went over some of those statistics above, right? Thousands and thousands and thousands of pages of regulations. Another figure that might make the point. How many federal criminal laws do we have today, right? The general police power in our constitutional system is reserved to the states. So you might think federal criminal laws would be reserved for the worst, or conduct so egregious it merits the attention of the federal government. Treason, crimes in the high seas, things of that sort. How many federal criminal laws do we have? No one knows. Department of Justice have set out, time and time again to count them. And the best they can ever come up with before giving up is that we have around 5,000 federal criminal statutory laws today, to say nothing of regulatory crimes, which again, no one knows, but the estimates hover around 300,000 crimes. Academics who have looked into it estimate that we are all committing, you are a felon, I'm a felon, we're all felons. Some folks say we commit three felonies a day, right? Not too far off, maybe, from the land of, the chief of Joseph Stalin's secret police who says, show me the man, I'll show you the crime. One facet of it is that we've many, 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 many more laws by orders of magnitude more than we had even a generation or two ago. And then the next thing we talk about is it's not just that we have too many laws, but the locus of that lawmaking has changed. And it's changed in two ways. It's changed on a horizontal level and a vertical level. So increasingly, many of the laws regulating how we live are made not at the local level, or state level, but have moved to DC. So there's sort of a vertical shift in lawmaking power from the local level in the states up to the federal government. Separately, even if you zero in on the federal government, the locus of lawmaking has changed from Congress, from our elected representatives, and has moved horizontally over to agencies, to unelected officials. So we're sort of three pieces of that shifts. And what we want to explore in the book, of course, is what happens to our society's framework, to rule of law values, to our liberties as individuals, when you have these quite profound changes happening in our laws.
I can see it playing out. I'm thinking back to my own civic education in high school. And so, there was enough of the general system of the government, like there's three branches of government and they check and balance each other. But this seems to fall into the class that wasn't taught, which includes how to do your taxes, which is actually kind of a specific example of this thing where there's so many rules or regulations about it. It's hard to uncover. It's hard to know what you are responsible for and what you're not, and how to conduct oneself such that you're not going to get convicted of a felony. But I'm curious. It seems like I agree with you that the sort of horizontal and vertical shifts are changing the effectiveness of laws. But I'm also curious, is it not just that there's too many laws, but that there's also an educational problem? There's a communication, sort of dissemination of the new information that is also aiding in this issue.
That's a great question. I think that it would be hard, given the sheer volume of laws and rules nowadays, to actually have any real education about the laws. And I might tell here sort of just a funny little factoid. The Internal Revenue Service, you bring up taxes, right, in the tax code, and obviously everyone's very aware of having to do their own tax of how complex it is. So the Internal Revenue Service once set up a hotline, and someone at some point in the agency decided to monitor how well they were doing. And it turns out they gave wrong answers about a third of the time, which is really remarkable. And I think they were hauled before Congress and were asked about this and asked about the error rate. And they said, well, the nation's tax laws are growing increasingly complex. And there's lots of changes that happen, in those tax codes. And that's why we're getting things wrong. And another time, the EPA, they also create a hotline. This particular hotline was to field questions about a complex law governing the disposal of hazardous waste. But they said they couldn't guarantee the accuracy of their advice. And prosecutors said that reliance on the agency's wrong information wouldn't qualify as a defense. And so I think if you have, even the so-called experts, in many cases, those who actually drafted the regulations, even if they can't understand the laws and regulations, I fear that we are beyond the point where statutory or regulatory or where education on statutory or regulatory requirements is the key.
Yeah, I'm listening to this, like, how, as a citizen, could you not look at this current context and feel so powerless in it and say, like, okay, well, why would I respond or try to adhere to any rule of law when the law has become, it's like, if everything's important, nothing's important. If I have to police every single action or every single whatever, it might be deemed unlawful. Like, why pay attention to any of the laws at all? Can we talk a little bit more about how local lawmaking differentiates in its effectiveness or its clarity than when things move up to DC and over to the executive branch and administrative positions?
So Laura, first of all, before I answer your question, I think it's a great point you make about where there is so much law. Will some people not sort of simply throw their hands up in a way and say, well, I don't know how to comply with any of it. We know in the book that back in 1967, a presidential commission had been convened to study the nation's criminal justice system. And they warned, and I'll quote here, that a, quote, substantial cost of overextended use of the criminal process is the risk of creating cynicism and indifference to the whole criminal law. Professor William Stuntz wrote a lot about this. He used to be my criminal law professor back in law school, and he would write, too much law amounts to no law at all, which I think is a great line too. But back to your question about sort of the local. So Laura, back to your question about how much do we mitigate the problem if we shift some of the lawmaking to be more local? And I think what you're hitting at is one of the key insights of the founders, which was that federalism. The idea that where we the people rule, you want rules to be made, laws to be made as close to the people as they can, right? Someone in Wisconsin may have a different view of how they would like to live their life than someone in Massachusetts, than someone in DC. A farmer may have a different view than a tavern owner. And we're a big country. We're a country at the end of the day of immigrants. And federalism gives us a way to sort of mediate our differences. We saw some of this come out in COVID, right? Where, again, someone on a factory floor 10 hours a day might have a different view about a mask mandate than someone sitting at home working on the laptop in their pajamas. Someone in a densely populated city might have a different view about the necessity of taking a vaccine than someone, in a more rural part of the state. And federalism was a way to allow us, again, to live together in harmony, given that we have different views. This isn't an insight that our founders had alone. In 1931, as totalitarianism was gaining ground in Europe, the Pope reaffirmed, and I'll quote here, I think it's a great quote, that it was, quote, an injustice and at the same time a grave evil and disturbance of the right order to assign to a greater and higher association what lesser and subordinate organizations to do. So this link of federalism and freedom has been animating human thinking for a long time. Some of the growth of our federal government, I think it's hard for those of us who weren't sort of born before the 60s to appreciate how much of it has arisen just in the last generation or two. For much of our history, as you know, responsibility, for example, for educating the young and setting public school policy was completely in the hands of parents and local and state institutions. Until 1979, the federal government did not have a cabinet-level Department of Education, and now, of course, that agency employs thousands of people and has a budget, I think, by last count, of almost $70 billion. So there's been a huge shift just in the last few decades. Again, 60s and 70s saw massive piece of legislation being passed, Clean Air Act, Clean Water Act, many of them sort of seminal piece of legislation that we can't understand sort of living without today. But it's important to note also that they are relatively new additions to our legal order.
What laws would fit being kicked back down to the local level versus the ones that should be at the federal level to, yes, mitigate our differences, but also ensure that differences within communities doesn't just destroy a community, destroy their access to continued longevity, or destroy access to inalienable rights within that community.
That is a big question. Let me try to take it on. So going back to, let's say, sort of the question of sort of what should Congress do versus the state level. Again, I think our history and our Constitution provides some answer for that. We did have an Article of Confederation that our founders thought actually did not leave enough power with the national government. And so the structure that they envision for our Constitution that we have today does leave power over these sort of big national issues, as you say, within Congress, within their enumerated powers. And so I don't see sort of a disconnect of, well, now that we have a more robust, let's say, international scene, that we all of a sudden can't allow Congress, that Congress doesn't have the power, shouldn't be involved in that scene. I don't think that's right. I think Congress left the Constitution left space for Congress to enact laws in that space. That said, again, I think on issues that were once local, education being one of the prime examples of it, we have moved so far away from where we once were. And I always like bringing up the story of Alexis de Tocqueville, who traveled around the country in the 1830s and, of course, came up with his seminal work, Democracy in America. And what struck me in reading that work for this book, I think I'd read only snippets here and there in law school beforehand, was the degree to which he marveled at how Americans were constantly coming together to form associations. And he said, he has this great quote. He said, "Everywhere that at the head of a new undertaking you see a government in France and a great lord in England, count on it, you will perceive an association in the United States." And that association, that sort of civic glue, I think, for Americans is another piece that gets lost when everything is sort of moved away to sort of far away in DC, right? That we are no longer coming together as parents in a community and saying, how do we want our kids to be educated? If we no longer have the power to do that, then I think you have something lost beyond just kind of local laws. And so I don't have sort of sitting here this incredibly clean answer for what should be at the federal government, level, what should be at the state or local level. But I do think looking back to our history can provide some answers.
Looking a little bit more at executive orders, how are they fitting into the arguments within the book? And also, I'm curious how you see the recent flood of executive orders playing into what you guys are talking about in the book, in that it's kind of a torrent of paperwork. It's hard to keep up with all the different ones coming out, perhaps in the hope that things get lost and some makes it through and some doesn't. But I'm curious how you see.
Sure. No, I think that's a really good question. And executive orders, of course, as your listeners know, are written directives from the president. They have the force of law, and presidential directives are similar. I remember when I first was working Office of Legal Counsel, I didn't quite understand the difference between executive orders and presidential directives, and it turns out there's actually not much of a big difference. But executive orders have, they have a very long historical pedigree in our nation, dating back to George Washington. So you have scholars that have put together some counts on executive orders per presidents. The American Presidency Project, run out of UC Santa Barbara, is one such organization. And, they noted that George Washington issued 8 in his 2 terms, which is, of course, small by comparison to where we are today. Now, the fact that executive orders on their face, have a long historical pedigree doesn't necessarily mean that their usage by any given executive in any given circumstance doesn't put pressure on rule of law values, which I think is a little bit of what your question is getting at. And, here I do think it's actually interesting to observe that the 2 presidents in our own nation's history who have issued the greatest number of executive orders, at least according to this American Presidency Project, I think the counts probably vary a little bit because back in the day they weren't as, standardized as they are now. Two presidents who issued the greatest number of executive orders were Presidents Woodrow Wilson and Franklin D. Roosevelt. And they didn't issue just a little bit more executive orders or a few more executive orders. It was a lot more. It was like huge orders of magnitude difference. So President Wilson issued 1,803, according to the American Presidency Project. FDR issued 3,721. And to put those numbers in perspective, President Obama issued 147, 129 in his two terms, and President Trump issued 220 in his first term. And so I do think that there is a lot of talk nowadays about executive orders being used more and more, and certainly as comparison to, much of our nation's history, I think that's right. But I do think it was actually interesting when I went back to these numbers of, okay, like 220 or 147 is nowhere near 3,721. And the reason I personally, coming at it, from my perspective, find those interesting is that those two Presidents Wilson and FDR, oversaw sort of massive increase in the scope and power of not just the federal government, but especially in FDR's case, in the power of the executive branch himself. Coincidence that their numbers are largest, or maybe not. But again, returning back to your question, yes, executive orders carry the force of law, but they do not, of course, comply with the bicameralism and presentment requirements of making new law through Congress, right? Famously, President Obama once said, I don't have to wait for legislation, I have a pen, right? So in light of those sentiments, I do think it's important to remember that our founders made lawmaking hard for a reason. Justice Gorsuch loves to say the difficulty of making new law in Congress is a feature of our Constitution. It's not a bug. And, if you think about the difficulties, so under our Constitution, any new law, which our founders understood as any new restriction on our freedom, it has to win approval from two houses of Congress, composed of elected representatives chosen by different constituencies for different periods of time, and even then has to earn the president's approval or, sufficient votes for an override. And, James Madison and his fellow founders purposely require such a long and deliberative process, one that is dependent on consensus, because they believed that it was valuable that any new law would enjoy wide social acceptance, would profit from an array of views, and as a result would prove more stable over time. They feared ever-changing laws. And this need for compromise, they believe, would also protect minority interests, because in a system where compromise is necessary, then you can't simply ignore sort of minority and unpopular views. Executive orders, again, by definition, they don't have to meet those requirements. They have very much in contrast the, quote, energy in the executive that Alexander Hamilton put it behind them. And that can have a virtue in some circumstances as well. But I think it comes back to, so it really depends on the context and specifics. And we do talk briefly, I won't go into detail here, but we do talk in the book, we have two sections on COVID era policies. And in that era, of course, as folks will remember, the use of executive authority, including executive orders, was widespread. And I think, listeners and readers can judge based on their own experiences or those we discuss in the book, whether they think those executive orders tracked the people's will, as of course law in a democratic republic should, or represented perhaps something else.
A feature of our system is that it's difficult to make laws on purpose. And I think for myself, at least, for our listeners, hopefully, just getting a different understanding and perspective on the historical components of this, and that it's being talked a lot about right now, particularly the executive branch and executive orders, but to recognize that this is a longer problem, or this is a long-standing practice. And how does it fit within the larger context of our nation's history? I would love to hear how you and Justice Gorsuch unpack, yes, lawmaking is supposed to be hard, but how does one make, or how is a good law formed? And on what merits do we judge a law as having achieved its purpose?
That is a hard question, because I think we purposely in the book shied away from, with a few exceptions, shied away from saying what a good law or not good law is, in part because, again, we, the people, should decide what our laws are. So if we, the people, come up with a silly law, at the end of the day, I think that's more palatable to me, at least, than if an unelected agency official comes up with a silly law. I remember that Jimmy Carter once, this is not in the book, but I wish we had gotten it in there somewhere. He complained that under his administration, it took 12 years and a hearing record of 100,000 pages for the FDA to decide what percentage of peanuts there ought to be in peanut butter. And I'm not sure that we, the representatives, would have spent our time on that. Now, should there be a few guardrails in the law? Yes, and we talk about that. We get into, I guess, in this ways for what we might view as good law and not good law a little bit. One of those that we talk about, we have a chapter on the criminal justice system, and we talk about the ways in which that the substance of our criminal laws, not just the number of our criminal laws and where they're being made, but the substance of them have also changed over the years. One of those examples is the decline of the requirement of mens rea in our laws. So for much of our nation's history, to secure a criminal conviction, the government had to prove that the defendant committed not just a bad act, but that he also acted with a particular mental state, or a bad mental state of mens rea. And this was a very ancient feature of Anglo-American law, and it rests on the belief of the freedom of human will, the idea that to sort of do something, to do a bad act intentionally was different than to do a bad act by mistake. And that requirement has, over the last, again, 100 years, sort of slowly been disappearing in some of our criminal laws. As another sort of guardrail, we have a section on licensing laws. Again, sort of some, 150 years ago, say, licensing requirements were largely required for medical professions. And the idea, of course, was to provide some assurance to the public that the doctor you were going to, or later the dentist you were going to, there was some sort of quality controls on that doctor. Those licensing requirements have expanded dramatically in recent times. And we talk about two stories out of Texas where licenses were required for a hair braider to work and an eyebrow threader to work. But there are many examples across the nation. I think it was Louisiana that now requires licenses for florists, and aspiring florists have to take an exam in which they're sort of the way in which they place flowers in a vase is judged, and of course judged by none other than the very people they would like to compete with, right? And so that's another area where we sort of talk about maybe maybe that's not a great substantive law to have, but beyond sort of some guardrails like that, I really think the point of our book is much more to note that, again, in a I think I sound like a broken record, but again, in a democratic republic found on self-rule, that it ultimately is up to we the people to decide what laws we have, subject obviously to constitutional constraints.
This is a bit intimidating of a project, particularly as a young person. I've got young friends, and looking at sort of the state of what you discuss in the book, it's intimidating. The problem is obvious. Are there any specific actions that you think would help individuals engage in the process of understanding the laws that are there, figuring out which laws are important to understand, and which ones do we call legislative fluff, and how to increase our participation in this process?
I love that question. I am a huge proponent of civic education. We have some sort of numbers on this in the last chapter of a book that I won't go into, but the bottom line is the state of our civic knowledge in this country is really, really quite something. It's not something good. And so I think the most important thing that people can do now is work on civic education, their own education, the education of their kids, of others in their community, and really get to a point where we understand, what does our Constitution actually say? Why does it say what does it say? What is the separation of powers? I think like less than half the people in our country can name the three branches of government. So, okay, let's learn what the three branches of government are. That's a start. But also, why did we divide them, right? And again, it comes back to that question of of individual liberty. And so I think civic education is a big piece of it. And I also think, I think this is part of the federalism piece. And we talk about this in the book, right? It feels very daunting if you feel like primary laws that are governing your life are being made away in DC, by people you have no access to, then I think there is a element of, a loss of desire to be involved because you feel like your involvement doesn't matter. And so my hope on the federalism piece is as we hopefully sort of bring back some of these laws back to a local level, that people will feel a re-engagement to get involved at the local level. But even before that, still get involved at your local level. You can join, local state governments. You can join, I'm on the Parents Association board at my school, which I feel very importantly, like find the community where you can, because I think a lot of this comes back again to Tocqueville's commentary about America being strong in part because people were just coming together and doing things. And I think that's really is a really important part of this nation, important history of this nation. And we are losing it slowly. Robert Putnam came out with his renowned books, or Bowling Alone, some 2 decades ago, I think, at this point. So I guess my message would be civic education and get involved where you can.
Well, Janie, thank you so much for coming on today's episode. It's been really fantastic to get a bigger perspective into the book and just hear your expertise. It's been delightful.
Thank you so much. This has been a really, really wonderful conversation. I'm so grateful that you had me on.
Thank you for tuning in on this particularly special episode of Madison's Notes. Make sure to subscribe on whatever platform you happen to be listening from so you can get notifications about next week's episode.